She fined me $1,400 for the ramp I built so I could get into my own house, not a neighbor's house, not the sidewalk, not any shared space, my own front door, my own property, the ramp I needed because I no longer have a left leg below the knee. I want you to sit with that for a second, because I still have to sometimes. They sent the notice on a Tuesday. The fine was listed under Section 4.7 of the Architectural Guidelines. Unapproved exterior modification. They attached a photograph. It was a picture of my ramp, clean cedar wood, properly anchored, professionally stained. Not an eyesore, not a hazard, just a way for me to get inside my home without falling. And the woman who signed that notice, Pamela Greer, HOA board president, drove a white Range Rover she parked in the fire lane outside the community pool every single Saturday. I'm going to come back to that detail. Remember it. If someone did this to you, someone filed a formal fine against you for accommodating your own disability in your own home, I want to know what you would have done. Tell me in the comments, because the night I got that letter, I sat in my car for a long time and I did not have a clear answer. Let me tell you who I am, and then let me tell you what I did. My name is Claudette Harden. I am 59 years old. I live at 1142 Willowfield Drive, Decatur, Georgia, and I have lived there for 11 years. I bought that house the year I turned 48, after a 27-year career with the Equal Employment Opportunity Commission. I retired as a senior federal investigator. My specialty, the thing I spent nearly 3 decades doing, was disability rights compliance, specifically the Americans with Disabilities Act, specifically the sections of the ADA and the Fair Housing Amendments Act that govern accessibility accommodations in residential housing. I want you to hold that information lightly for now. It matters. It matters more than I can tell you yet. I lost my left leg on a job site in 2019. I was there as a federal compliance observer, reviewing accessibility accommodations at a new distribution facility outside of Macon. A forklift operator who had been running a double shift lost control of the load. He did not see me. I woke up 3 days later in a hospital room in Macon with my daughter holding my hand and a surgeon explaining very carefully what was gone. I do not tell you this for sympathy. I tell you because you need to understand the sequence, the injury, the recovery, the 18 months of physical therapy in Atlanta, the prosthetic fittings, which take longer and hurt more and cost more than anyone tells you before it happens. And then the moment, 14 months after the accident, when I came home from a rehab session, stood in my driveway and looked at my own front porch steps and understood that they were now an obstacle. 3 steps, nothing to hold. A wooden railing that I had never once thought about, because I had never needed to. I had a contractor build the ramp that fall. Cedar wood, code compliant, anchored into the ground with concrete footings, with a non-slip surface and a gentle grade that my physical therapist had approved. I paid $4,200 for it. I did not ask Pamela Greer's permission. I did not submit an architectural review request. And I want to be honest with you. I did not think I needed to. That was my first mistake, not a moral mistake, a procedural one. And I want to come back to that because it matters to what came later. The notice arrived on a Tuesday in March. $1,400, Section 4.7, unapproved exterior modification. I read it twice, standing in the kitchen with my coffee getting cold on the counter. Then I read it a third time. I am not a person who reacts loudly. I have spent most of my professional life sitting across from people who expected me to react and making the deliberate choice not to. But that morning, alone in my kitchen, holding a sheet of paper that told me I had violated community standards by building a way to enter my own home, I felt something I do not have a clean word for. It was not anger. It was something closer to disbelief that had turned cold. The kind of stillness that comes when something is so wrong that your body goes quiet waiting for your brain to catch up. I set the notice on the kitchen table. I went to the window. Outside, my ramp was sitting in the morning sun, exactly as I had left it, exactly as I needed it. It was not going anywhere. Neither was I. Pamela Greer had been the board president of Willowfield Commons for 4 years. I had met her twice, once at a welcome committee event when I moved in, and once at a board meeting where she had discussed mulch color guidelines with the kind of intensity most people reserve for natural disasters. She was 61 years old, small and meticulously put together, with reading glasses she wore on a chain and a way of tilting her head when she spoke to you that communicated, without saying anything, that she had already decided how the conversation would end. The first time I spoke to her about the fine, she was standing at her mailbox on a Tuesday afternoon. I walked over, on my ramp, down my driveway, along the street. She watched me coming. She did not look away. I told her I had received the notice and that I wanted to understand the basis for it before I responded formally. She smiled, not unkindly. It was more patient than unkind. She said, "Ms. Hardin, I understand this is frustrating, but we have standards in this community, and standards exist for everyone." That was the sentence. That specific sentence. I want you to hold it. She told me that the architectural review process existed to protect community appearance and property values. She told me that the ramp, as installed, had not been approved through that process. She told me that I could submit a retroactive application, which would cost $75 and take 30 to 45 days to review, but that there was no guarantee of approval given the placement and the materials. And then she said, with that head tilt, "I do hope you understand that this is nothing personal." I told her I understood, and I thanked her for her time. I did not tell her what I knew. I did not tell her what I had done for 27 years, or what I recognized the moment she said the words, "Standards exist for everyone," in the context of a disabled homeowner who had built an accessibility modification. I did not tell her that the phrase she had just used, and the action it was attached to, had a specific legal name, a specific federal statute behind it, and a specific enforcement mechanism she had never once considered. I went home. I made tea. I sat at the kitchen table with the fine notice, and I started writing things down. The first thing I wrote was a number, 42. That is the section of the United States Code. 42 U.S.C. Paragraph 3604F, under which the Fair Housing Act's disability provisions live, specifically the provision that makes it unlawful to refuse to make reasonable accommodations in rules, policies, practices, or services, or to refuse to allow reasonable modifications, when such accommodations or modifications may be necessary to afford a person with a disability equal opportunity to use and enjoy a dwelling. Let me give you the plain English version, because this is something every homeowner with a disability or with a family member who has a disability needs to know. A condominium association, an HOA, a cooperative, a landlord. They are not allowed to deny a disabled resident the right to make reasonable modifications to their own home if those modifications are necessary for the resident to use and enjoy the property. They can require you to pay for it yourself. In some cases, they can require you to restore the property when you leave. But they cannot say no. They cannot fine you for asking, and they absolutely cannot fine you for doing it. The ADA and the Fair Housing Act are federal law. They are not optional. They do not yield to Section 4.7 of the Willowfield Commons Architectural Guidelines. I knew this the way I knew my own name. I had spent the better part of 3 decades enforcing it. But here is something I learned a long time ago in federal investigations. Knowing something is not the same as proving it, and proving it is not the same as resolving it. Pamela Greer had filed that fine. She had created a paper record. Before I responded to that record, I needed to understand what else was in it. So I made a call. Marcus Tillman had been a staff attorney at the Atlanta Legal Aid Society when I was still at the EEOC. I had referred cases to his office more than once over the years. Housing discrimination cases, accessibility cases, cases that started as a workplace complaints and opened into something larger. He had moved into private practice in 2021, a two-attorney firm on Peachtree Street that handled fair housing and disability rights. He was 44 years old, quiet the way a river is quiet. You do not notice the current until something is already moving. I called him on a Wednesday morning. I told him what had happened. He listened without interrupting. When I finished, he was quiet for a moment, and then he said, "How long has she been on the board?" I told him 4 years. He said, "Pull the board minutes for all 4 years if you can get them. HOA board minutes are public record in Georgia, and I want the architectural review records, every approval and denial for the last 4 years. I said I could do that. He said, "Claudette, before you do anything else, is this the first time you've heard of her filing a fine like this?" I told him I did not know. He said, "Find out." That call was the checkpoint. That was the moment the thing I had been carrying alone became something we were building together. But I want you to understand, I was not safe yet, not even close. I submitted the public records request to the HOA's management company that same week. Under Georgia law, homeowners have the right to inspect and copy certain HOA records, including board meeting minutes, financial statements, and the governing documents. I requested 4 years of architectural review applications and decisions. I requested board meeting minutes for the same period. I requested a complete record of all fines assessed in the development since Pamela Greer had taken the board presidency. The management company's initial response arrived 8 days later. It acknowledged my request and informed me that the documents would be available for inspection at their office within 30 days. 2 days after that response arrived, I got a second notice. This one was not a fine. It was a letter from the board, signed by Pamela Greer, informing me that due to my failure to cure the unapproved modification within the required 30-day period, the fine had been escalated to $2,800, and that an assessment lien would be filed against my property within 14 days if the modification was not removed or the fine paid. They wanted me to remove the ramp or pay nearly $3,000. I want you to understand what that moment felt like. Not the legal strategy, not the calculation, just the human reality of sitting in your own house, reading a letter that tells you the way you built a path to your own front door is going to be turned into a debt attached to the deed of your home, a lien, on the house I had owned outright since 2017, for a ramp I needed because I lost a leg going to work. I almost called Marcus and told him I would pay it. Not because I thought they were right, because I was tired, because there are days when the prosthetic does not fit right, and your body is reminding you of everything it has been through, and the last thing you want is a fight. Because sometimes dignity costs too much, and you just want it to stop. I did not call Marcus to say pay it, but I thought about it, and I want to be honest with you about that, because I think there are people watching this right now who have made that call, who have paid the fine, or removed the modification, or moved out because fighting cost more than they had. I understand that. I am not here to judge it. Have you ever been told that the way you've adapted to something painful in your life doesn't meet someone else's standards? Have you ever had someone look at how you survive and call it a violation? Tell me in the comments, because I want to know. I'm not the only one who has sat with that. I did not pay. I sent a formal written response through Marcus's office, invoking 42 U.S.C. paragraph 3604 at EF 3A and the corresponding Fair Housing Act regulations, and notifying the HOA that the fine and threatened lien constituted an unlawful refusal to permit a reasonable modification by a disabled resident. The letter cited my documented disability, amputation, service-related, and demanded that the fine be rescinded and the lien threat withdrawn within 10 business days. Marcus told me to expect silence or escalation. He did not expect reasonable people making a reasonable decision on the other side. He was right. 11 days after that letter was sent, I received a phone call from a woman named Desiree Vance. She identified herself as an attorney representing the Willowfield Commons HOA. She was smooth and professional, and she told me that the board had reviewed my letter and had concluded that it was without merit, that the architectural review process was a legitimate exercise of the HOA's authority, and that the modification in question remained unapproved. She said the lien would proceed. She also said, in a tone that I recognized from 27 years of working with people who want you to feel small, that I should consider the costs and disruption of litigation before I chose to pursue this further. I thanked her for the call. I told her I would be in touch. That night was the night I painted the magnolia on my socket. I do not know exactly when I started doing it. After the accident, during the long months of therapy, I started decorating the sockets as a way of making the thing mine, making it part of me instead of something attached to me. The one I was wearing that November had a small magnolia on the outer face, painted in matte white on a matte black background. I painted it myself with a fine brush, the kind I used when I made Christmas cards for my grandchildren. It took me 2 hours and 3 attempts to get the petals right. I sat at the kitchen table that night with the socket off and the brush in my hand, and I thought about Pamela Greer telling me that standards exist for everyone. And I thought about Desiree Vance telling me to consider the costs and disruption. And I thought about the ramp on my porch, which I had not removed and would not remove, and about the magnolia I was painting, which I had not asked permission for and would not ask permission for either. I was done being careful. I was done being patient. I was going to be precise. The records arrived from the management company 23 days after my request. 4 banker's boxes. I signed for them on a Thursday morning, and I put them on the dining room table, and I started reading. What I found in those boxes took me 3 evenings to process fully. And what I found, I want to tell you clearly, because this is the part that changed everything. In 4 years of Pamela Greer's board presidency, the Architectural Review Committee had received 47 modification requests. Of those 47, 39 had been approved. 8 had been denied or fined. Of the 8 that had been denied or fined, 3 involved accessibility modifications, a wheelchair ramp, a widened doorway, a grab bar installation on an exterior deck. All 3 were owned by residents with documented disabilities. None of the 39 approved modifications were accessibility related. They were decks, garden features, exterior paint colors, shutters, and in one case, a decorative water feature Pamela Greer's next-door neighbor had installed in a backyard visible from the street. That water feature had been approved in 5 days. My ramp, the one I needed to enter my house, had been fined inside of 30 days without ever being reviewed. I sat with that for a long time. I want you to sit with it too, because what I had in front of me was not just one mistake or one overzealous board president. What I had in front of me was a documented pattern. 3 disabled homeowners, 3 accessibility modifications, 3 denials or fines, 0 approvals. Under the Fair Housing Act, a pattern or practice of discrimination does not require you to prove intent. You prove disparate impact. You show the numbers. You show what happened to people with disabilities compared to people without. And you let the pattern speak. Marcus, when I called him that Friday morning, was quiet for longer than usual. Then he said, "We're filing with HOA. I want to tell you what happens when a complaint is filed with the United States Department of Housing and Urban Development's Office of Fair Housing and Equal Opportunity, because this is the knowledge nugget I want you to take from this, whether you ever need it or not. When HUD receives a fair housing complaint, they have 100 days to investigate. During that investigation, they can subpoena documents, interview witnesses, and review the records of the respondent, in this case, the HOA and its board. If HUD finds reasonable cause to believe that discrimination has occurred, they can refer the matter to the Department of Justice. The DOJ can file suit on behalf of affected residents. Damages in fair housing cases include compensatory damages for the harm suffered, civil penalties, and in pattern or practice cases, civil penalties that can reach tens of thousands of dollars per violation. The HOA did not know this was coming. But here is the part I want you to remember. Neither did the 2 other homeowners whose modifications had been denied. Marcus located them both. James Curry, 67, a widower in the northeast corner of the development, who had widened his bathroom doorway after a stroke. He had removed the widened frame and reinstalled the original doorway. He had paid the fine. He had not told anyone. And Dorothy Simmons, 72, a retired teacher who had installed grab bars on her deck and been told to remove them or face a $2,000 fine. She had removed them and fallen 6 months later on that same deck. Her daughter had helped her move into an assisted living facility shortly after. Dorothy was not there to tell her story anymore, but her daughter was. And when Marcus called her, she said, "I have been waiting for someone to call me about this for 2 years." The hearing date was set for February 14th. That gave us 9 weeks. I want to tell you about the week before the hearing, because this is the part I have trouble with still. On January 31st, a white envelope appeared in my mailbox with no return address. Inside was a single printed page. It said that if I chose to pursue the complaint, a review of my EEOC case files during my tenure could find irregularities worth examining. It said I should consider whether the disruption was worth it. It was not signed. I do not know with certainty who sent it. I have my beliefs. What I know is what I did with it. I put it in a plastic sleeve, labeled it with the date and time I found it, photographed it in place before I touched it, and handed it to Marcus at our meeting the following morning. He looked at it for a long time. Then he said, "This goes to the HUD investigator today." I told him I had already emailed the photograph. That night I sat on my porch. The ramp was there under me. The street lights were on. It was cold for Georgia, not cold by real standards, but the kind of cold that makes you want to be still. I sat there in my coat with my coffee and my prosthetic leg, and I thought about Dorothy Simmons, who had installed grab bars and removed them and fallen and was not in her house anymore. I thought about James Curry, who had paid a fine and rebuilt a wall and never told anyone. I thought about the magnolia on my socket. And I thought about a piece of federal law I had spent nearly 3 decades enforcing, that had sat in those boxes all along, waiting to be read by someone who knew what it said. The morning of February 14th, I put on my good suit, the charcoal one with the gold buttons, the one I wore to every federal hearing I had ever attended. I carried the same briefcase I had carried for 27 years. Marcus met me in the lobby of the federal building on Spring Street at 8:45. The HUD administrative hearing was held in a small wood-paneled room on the 4th floor. Pamela Greer arrived with Desiree Vance and a second attorney I did not recognize. She was wearing a cream blazer and her reading glasses on the chain. She looked at me across the room with the same expression she had used at the mailbox, patient, composed, certain of the ending. The HUD administrative law judge was a woman named Eloise Hartley. She had been a fair housing attorney for 16 years before joining HOA. She read the complaint record without expression. She read the architectural review data. She read the 3 files, mine, James Curry's, Dorothy Simmons's. She asked Desiree Vance to explain the basis for the 3 denials. Vance said that all 3 modifications had failed to meet the architectural review standards as applied uniformly across the community. Judge Hartley asked her to identify the specific standard that the 3 modifications had failed to meet, and to compare that standard against the 39 approved modifications in the same 4-year period. There was a pause, not a short one. Vance asked for time to confer with her client. The judge gave her 5 minutes. When they came back, Pamela Greer's composure was still there, but something had shifted in it. The certainty was gone. She was holding it in place now instead of simply having it. I watched it happen. I did not look away. The proceedings lasted 4 hours. I'm not going to walk you through every minute. What I will tell you is the outcome. HUD found reasonable cause to believe that the Willowfield Commons HOA had violated the Fair Housing Act's disability provisions through a pattern of denying reasonable modification requests from disabled residents. The case was referred to the Civil Rights Division of the Department of Justice. The fine against my property was declared void and ordered expunged. A consent decree was entered requiring the HOA to revise its architectural review process to comply with federal accessibility law, to provide fair housing training for all board members, and to pay compensatory damages to James Curry and to Dorothy Simmons' estate. My fine, $0, expunged, ramp, stays. The HOA's legal exposure under the consent decree, $112,000 in remediation, training costs, and damages. When I left that building, Marcus held the door for me. The ramp at the base of the federal building steps was a standard aluminum accessibility ramp, permanently installed, code compliant, exactly like every federal building I had ever walked into in my career. I had never once thought about it before. I thought about it that day. I drove home. I made tea. I sat on my porch. The ramp was there. The magnolia was on my leg. The neighborhood was quiet the way it gets in the early afternoon. That particular Georgia February silence, thin and pale and still. I did not feel triumphant. I felt steady. I felt like I had done the thing I was supposed to do and it had held, and now it was done, and I could sit here. Pamela Greer resigned from the board the following month. I did not learn this from a public announcement. I learned it from a neighbor who stopped me on the street to tell me, in a quiet voice, that she was sorry she had not known sooner. I thanked her. I meant it. What I want to leave you with is this. The Americans with Disabilities Act and the Fair Housing Act exist for a reason. They exist because for a long time, disabled Americans were expected to adapt to a built world that was not designed for them, to ask permission to use the space they owned, to pay fines for the modifications they needed. Those laws did not eliminate that dynamic. I watched it operate for 27 years and I lived it myself. But those laws gave people a tool, a documented right, a place to stand. If you are a homeowner with a disability, or if you live with or care for someone who is, you do not need permission to make reasonable modifications to your own home. You need to document your disability. You need to notify your HOA in writing. And if they fine you or refuse you or threaten your deed, you need to know that the Department of Housing and Urban Development has an Office of Fair Housing and Equal Opportunity that takes complaints, investigates them, and acts on them. Free of charge. That office exists. It has teeth. Use it. Know your rights, not as a technicality, as the thing between you and someone who decided your standard of living was a violation. My name is Claudette Hardin. I am 59 years old. I live at 1142 Willowfield Drive, Decatur, Georgia. My ramp is still there. My magnolia is still on my leg. I did not remove either of them, and I do not intend to. She said standards exist for everyone. She was right, including federal ones she had never read. If you have an HOA story, a fine, a lien, a modification denied, a board president who decided your needs were a problem, drop it in the comments. I read everyone. And if this story meant something to you, if it told you something you needed to hear, share it. There is someone watching right now who is sitting with a fine notice on their kitchen table and thinking they have no options. Show them they do. Next week, I want you to hear from a man in Memphis who spent 6 months convincing his HOA he was not required to pay dues because the deed his grandmother signed in 1968 predated the HOA's founding by 11 years and contained a restriction clause that made the entire covenant unenforceable against her parcel. His name is on her deed. He is still in that house. Wait until you hear what a deed restriction survives. You are going to want to be there for that one.